they're really trying to go for that high risk, high reward strategy, then they have to go all the way. And I think this is one of those rare instances where the defendant needs to take the stand. A Massachusetts doctor stands accused of strangling his wife before dumping her body in a nearby pond. His defense says it's a case of heat of passion manslaughter. Plus, a Michigan woman goes to trial for the second time in nearly 20 years after investigators say she beat, then burned, then ran over her husband with a van. And last-minute pivotal rulings that could shape the landscape of the retrial of Boston area woman Karen Reed. All this and more this week on Courtroom Confidential. We've got new trials, retrials, and plenty more to cover this week. We're recording this on Friday, April 4th, 2025, and this is your Courtroom Confidential weekly roundup. First, trial continues for a Massachusetts doctor accused of murdering his wife and dumping her body in a nearby pond. Dr. Ingolf Tuerk is charged with strangling Kathleen Katie McLean to death in their home in May of 2020. He faces life in prison if convicted. Harry's defense argues that Katie died during a drunken fight over their strained relationship. The couple had recently dropped efforts to divorce after a turbulent period that included Katie reporting Harry to police for physical abuse and Harry's suspicions that Katie was cheating on him. Last Friday, jurors visited key locations in the case, including the couple's home, a nearby motel where Harry was found unresponsive, and the pond where Katie's body was later found. That same day, Kurt Fennenstiel, a neighbor of the couple, testified that Harry once referred to Katie as, quote, the devil in a text message and expressed regret about marrying her. Kurt also admitted to exchanging flirtatious messages with Katie, a detail the defense highlighted during cross-examination when he returned to the stand on Monday. On Tuesday, Massachusetts State Police Sergeant Jeffrey Kutkowski recounted interviewing Harry at the hospital on May 16th. According to Kutkowski, Harry admitted to drinking and having a physical altercation with Katie, ultimately confessing, quote, I choked her. He directed police to the pond, saying he believed she was there. Wednesday's proceedings included testimony from Dr. Michelle Matthews, the medical examiner who performed Katie's autopsy. She confirmed that Katie died from strangulation. Court proceedings paused Wednesday and are set to resume on Monday. Well, what's happening here? First off, this is not a whodunit. This is not a case of an alibi. This is not a case of self-defense. This is one of those rare cases where you have high risk, high reward, where the defense is essentially admitting that, yes, he killed her. Now, they're saying that he killed her, but he had a reason, or rather, it was a blinding moment of heated passion. In other words, they're trying to offer some sort of explanation for his actions, but not entirely an excuse for his conduct. Let's talk a little bit about heat of passion. Heat of passion requires some sort of intense or strong emotion that is triggered by a provocation that causes a person to act impulsively. In this case, the defense is saying that, listen, they were highly intoxicated. He had evidence that she was perhaps having an affair. There's no evidence that he premeditated this. There's no evidence of a weapon being used. There's no evidence of planning. And in that volatile, highly charged emotional moment, that he just snapped and he was triggered. And he acted within that heat of passion and committed this horrible, horrible crime. But because of that, this is not first-degree murder. Instead, as the law allows, this should be viewed as voluntary manslaughter, greatly reducing his exposure in prison. The prosecution, on the other hand, responds to all of this with saying, well, first of all, you cannot look at this one moment in a vacuum. You have to look at the history of violence and abuse that took place within that marriage. And he was, according to prosecutors, abusive towards her. There were also previous conversations that he had with other people where he was talking about how he felt about her, how he called her a vindictive devil, how he wanted out of the marriage himself. This was a rising tension, not some momentary provocation, but a bubbling over, slowly simmering type of thing that culminated in this murder. They're saying then you have to look at the efforts that he took to cover it all up. But I think more than anything, they point towards the way that he killed her above all else. Strangulation. And we have to think about this. And this is a little bit graphic, but Strangling someone is not like what you see in the movies. This is not quick. This is not a moment where in a flash of violence, someone grabs someone else by the neck and then they're dead. This takes time. This takes great physical effort. In fact, this takes a great struggle. And he had defensive wounds on him. And the prosecution is saying, and I think effectively, that during that entire time, when he had his hands wrapped around her neck and the life was slowly draining out of her, that he was choosing with each passing moment to kill her. And that is the premeditation that we're talking about. Premeditation is not something that requires planning extensively, where somebody sits down and really thinks about how they're going to commit a murder. It involves somebody thinking, perhaps even in a moment, deciding with intent to go ahead and take someone's life. And they're saying that in any moment, while he had his hands wrapped around her neck, he was deciding to take her life. And that is the premeditation required for first-degree murder. One final thought on this case. Like I said, it is a high-risk, high-reward strategy that the defense is taking here. They're saying, yes, our client did it. Not it was self-defense, not our client was somewhere else, not somebody else is responsible for this. Yes, our client did it, but he was provoked. He didn't have the requisite intent. He acted in the heat of passion. Who is best situated to explain that all to the jury but the defendant himself? I think that if they're really trying to shoot for the moon in this case, if they're really trying to go for that high risk, high reward strategy, then they have to go all the way. And I think this is one of those rare instances where the defendant needs to take the stand. He needs to swear an oath and stand in front of those jurors himself, look them in the eye and say, this is what happened. I am full of regret. I am not this person. I did not plan this. It was in that blind fury of emotion that I acted. And that's why I did the horrible thing that I did. If he really wants a chance at voluntary manslaughter, I think that's what he needs to do. But what do you guys think? Do you think this is one of those rare cases where the defendant actually needs to testify? Please let us know in the comments. Trial continues for a Michigan woman accused of beating her husband, setting him on fire, and running him over with their van. Linda Stermer was convicted of first-degree murder in 2010 for the death of her husband, Todd Stermer, but that conviction was overturned in 2018 after a court found she had not received a fair trial. Prosecutors allege that on January 7th of 2007, Linda attacked Todd while he was sleeping, set their home on fire, and then ran him over outside as he fled the burning house with his upper torso engulfed in flames. Todd died from a combination of blunt force trauma and burns. On Tuesday, an insurance fire investigator testified that Linda gave inconsistent accounts of what happened and had discussed leaving her husband prior to the fire. Linda suggested Todd set the fire in an effort to kill them both. Testimony on Thursday included retired fire investigator Scott Leroy walking jurors through photos of the charred remains and explained that the fire was incendiary, meaning it was deliberately set under circumstances where it should not have been. He concluded that Todd's burns indicated he was near the point of origin and that gasoline was found on the sweatpants he was wearing. On cross, the defense challenged the investigation, and Leroy acknowledged that he could not determine the precise cause of ignition. Later, the prosecution called to the stand a gas station cashier who served Linda hours before the fire. She testified she saw Linda insert the gas nozzle into the rear window of her vehicle. She said she couldn't see exactly where the fuel went, but didn't question it at the time, noting that some customers filled gas cans inside their cars. Trial is expected to last through next week. What's happening here? First, let's talk a little bit about why this case was overturned. And this is something that troubles me a little bit. Here, the court found that there was ineffective assistance of counsel. And now this is a often argued yet rarely granted reason for overturning a trial. Much of what attorneys do are strategic decisions in a trial, and it is rare for that strategy to be questioned to the point of saying that it was ineffective assistance of counsel. Strategy simply sometimes doesn't always win. Trials are fluid. Many times attorneys are making decisions drawing from the hip. So the idea that the failure to call an arson expert, and that's exactly what the appellate court said, is the failure to call an arson expert in this case essentially was ineffective assistance of counsel. And for that reason, she should be given a new trial. Well, on top of the idea that this is a strategy decision, think about all the other reasons why an expert might not be called. First of all, and not the least of which, money. Sometimes you simply cannot afford it. Experts are not free. Also, finding the expert can prove to be difficult. Finding an expert who will give you an opinion worth putting on can be difficult. So for all of these reasons, we don't know what they were. The defense did not call an expert, and that might not have been for lack of wanting to or for lack of trying to. On top of all of this, you have to say that the failure to do something, in this case, the failure to call that expert, would have had an effect on the outcome of the trial. And I, again, wonder if that's truly the case here. But here we are. So let's talk about the case here. First of all, something very interesting is going to happen in this case, we expect. And that is that the prosecution has said that they intend to call her children, Linda Stermer's children, to the stand to testify for the prosecution. And I don't know if they're going to be called to say what they believe. I imagine that would be objected to by the defense, whether or not they believe that their mother is responsible for these murders. It could have to do with comments that she made ahead of time, setting a timeline, talking about her reaction after the murders, any number of things. But I'll just say this. Think about it from an optics perspective. How will the jurors respond to this? I cannot think of something that would be more emotionally persuasive to jurors than the idea that the family members of the defendant are in fact testifying against her. I think when this is all said and done, that will probably be a moment we look back on as being a turning point in this case. One last thing in this case worth talking about, and it's something that always gives me sweaty palms when I think about it, but this is a jurisdiction where the jurors are allowed to ask questions. And my gut reaction is always, I don't like it. And I've thought long and hard about why that is, and I think I might be wrong on this. The end of the day, the jurors are the ones who are going to be making the decisions. As trial attorneys, we take such great efforts to make sure that the evidence that is given to the jurors, that the questions that are asked of witnesses, that the exhibits that are marked are all things that have been heavily litigated and heavily planned and fit into a strategy on both sides, prosecution and defense. And so the idea that that control would be put in the hands of someone else, in this case, the jurors, is something that, like I said, keeps me up a little bit at night. But if we think about it, they're the ones who really matter. They're the ones whose questions really matter. And if they want to know certain things, then why not answer them for them? Also, think about the advantage that might give to both the prosecution and the defense to kind of know where the jurors are going, what they're thinking about, what they're perhaps struggling with. As the prosecution, perhaps you can give them those answers rather than allowing them to go back to deliberate with those answers still in their minds. And as the defense, maybe you can play into those questions. It's just an interesting thought. But what do you guys think? Do you like it when jurors are able to ask questions? What question do you think you would have in this case? Please let us know in the comments. Karen Reed, the Massachusetts woman accused of killing her boyfriend, Boston police officer John O'Keefe, has taken her case to the U.S. Supreme Court as jury selection continues in her retrial. In a filing submitted Thursday night, Reed asked the court to consider what her defense team describes as a, quote, unanimous but unannounced decision by a jury in her first trial that the prosecution failed to prove its case. Her attorneys have argued that jurors came forward after the first trial to say that they had agreed to acquit her of second-degree murder and leaving the scene of a fatal crash, and were only deadlocked on the charge of manslaughter. Lower courts have rejected previous motions to drop the charges, prompting her legal team to escalate the matter to the nation's highest court. Meanwhile, earlier this week back in Norfolk Superior Court, Judge Beverly Cannoni issued two consequential evidentiary decisions in the quickly approaching retrial. First, Reed's defense had intended to have retired FBI Special Agent Michael Easter testify as an expert on police procedure to highlight the shortcomings of the investigation. Although ultimately denying the defense request, Judge Cannoni did comment that, quote, through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. Next, Judge Cannoni denied the defense request to present a third-party culprit defense as to Colin Albert, but would allow for the possibility of such evidence concerning Brian Albert and Brian Higgins. Quote, to protect the defendant's right to a fair trial, and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did in the first trial. Defense counsel are ordered not to mention potential third-party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. All this as jury selection for the retrial is moving quickly. As of Thursday, 10 jurors, 5 men and 5 women, had been seated after just 3 days of questioning. Court officials aim to seat 16 total, 12 deliberating jurors plus 4 alternates. Of the prospective jurors summoned, the vast majority indicate they have heard of the case, more than half acknowledging they had already formed an opinion. Jury selection is expected to last through next week. Well, what's happening here? Let's first talk about this idea that the judge is not allowing for a police procedure expert. First of all, the use of these types of experts is rare. This is not the first time defense attorneys have ever asked for it. You see this come up every now and then when the defense is trying to make the investigation itself part of the case. The investigation itself should be put on trial, which is something that the defense did to great effect the first time around. So we're back to that same playbook, and they're saying this time around to bolster those arguments, to further explain and explore the ideas of just how bad this investigation was, we want to put up an expert. We want to put up a retired FBI agent and have him walk through everything that the police department either did or did not do in this case and how that messed up this case from the word go. It is rare to allow this, though. And the reason for that is, in the simplest of terms, experts are for helping the jury understand something that they cannot on their own. Think about it this way. A jury may be able to see pictures of a body and appreciate that that person is in fact dead. But you need a medical examiner to explain to them the cause and manner of death. We're all used to that. We all accept that. We all understand why that is. Conversely, a jury may be told that it was below freezing outside. But we don't need to call an expert, a meteorologist, to take the stand and explain to us exactly that below freezing means cold. In this case, though, it's about something else I think that the judge is concerned with. And I think that's about the jurors substituting their own opinion for the expert's opinion. In other words, will the expert take the role of doing some of the juror's job? Jurors, a jury, is oftentimes referred to in the law as the finders of fact. They are the ones to decide, was this a good investigation or was it a bad investigation? And if it was, what does that mean? They're going to hear about the solo cups. They're going to hear about the grocery bags. They're going to hear about the leaf blower, and it's up to them to decide, was all of that so outside of norms and so bad that it affected the overall investigation and we should throw the baby out with the bathwater in this case? Or would they, if they heard from an expert explaining to them how bad all of that was, would they substitute that expert's opinion, his opinion being this investigation was beyond flawed and is not reliable, would they substitute his opinion for their own opinion? And I think that is what the judge is most concerned with in this case. Allow the jurors to do their jobs, give them the evidence to make their own decisions. Don't spoon feed it to them through an expert that they might substitute that expert's opinion for their own. Finally, as far as this third-party culprit argument, it's a win for the defense. All they needed was a way to open that door. As long as the judge allows for the same type of exploration of those issues that she did the first time around, the defense is on very solid ground. They will charge right through that open door like they did last time. It's not about whether or not it's Cullen or whether or not it's the Bryants. It's the fact that it's the judge allowing them to say it was somebody else and not their client. That's the whole point of this, and that's why The judge allowing for this argument to be explored and finally argued is a win for the defense. But what do you guys think? What do you guys think will be different this time around than from the first trial? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask one very small favor from you, and that is, if you haven't already, please take a moment to subscribe to this channel now. It is our goal to continue to provide you with the highest quality content that we possibly can, and the best way we can do that is through your support. And please don't forget to check out Courtroom Confidential, the podcast. Please join our community on all major podcast platforms. Also making headlines, a jury of 16 has been selected in Arizona to decide the fate of the infamous Doomsday Mom for murder conspiracy charges. Lori Vallow is already serving a life sentence in Idaho for the murders of her two children, Tylee Ryan and JJ Vallow, and conspiracy to kill her husband's first wife, Tammy Daybell. Now she faces trial in Maricopa County for conspiring in the July 2019 shooting death of her former husband, Charles Vallow. And this time around, she is representing herself. Jury selection began Monday and concluded Tuesday when 13 men and 3 women were sworn in. 12 will serve as jurors with 4 alternates. During jury selection on Tuesday, Vallow spoke directly to potential jurors. Quote, "You're basically here to protect me from the state," she said. "The prosecution is the state, the judge is the state, and law enforcement is the state. And so it's all of them against me." Prosecutor Trina Kay objected, prompting Judge Justin Boreski to clarify that the judge's role is to determine whether the state has proven its case, not to protect the defendant. Vallow also repeatedly asked jurors about their thoughts on her potentially taking the stand. Quote, "Would anybody have a problem with the fact that if I don't tell any of my side of the story," she asked, "if they didn't prove that I committed a crime at all, would anyone say, well, I can't find you innocent until you tell me what happened?" Vallow, typically seen in an orange jumpsuit and handcuffs and shackles, will be allowed to wear civilian clothes and remain unrestrained during the trial. However, Judge Boreski ordered her to wear a stun belt, which can deliver a shock if she attempts to flee. Deputies will be also stationed at the courtroom exits. Vallow has also been charged with conspiracy charges in the attempted murder of her niece's estranged husband, Brandon Boudreaux, who survived a drive-by shooting. No trial date has yet been set in that case. Vallow's trial will resume on April 7th with opening statements. An Arizona father will now stand trial for first-degree murder in the death of his 2-year-old daughter after rejecting a plea deal offer of second-degree murder. Christopher Shoutouts confirmed his decision to reject the offer during a court hearing last week in a Pima County Superior Court. Shoutouts' daughter died after being left in the family car for what prosecutors allege was close to 3 hours as temperatures soared past 111 degrees Fahrenheit. Investigators believe he was inside his home playing video games while she slept in the back seat. Text messages from Shoutouts' wife indicate she had previously warned him about leaving their children in the car. Reports also indicate his eldest daughter from a previous marriage told investigators that she had also been left in hot cars multiple times in the past. The plea deal would have reduced Shoutouts' exposure to a potential sentence of 10 to 24 years, while first-degree murder carries a life sentence. Shoutouts remains out of custody after a judge allowed his release without bond during his initial court appearance in July of 2024. Trial is set for October 27th. An anesthesiologist accused of attempting to kill his wife on a Hawaiian hiking trail had previously accused her of infidelity, leading to, quote, extreme jealousy, according to a restraining order petition filed last week. Gerhard Koenig had been charged with attempted second-degree murder after prosecutors say he repeatedly bashed his wife's head with a rock and tried to inject her with syringes containing unknown substances. In the petition, Koenig's wife described how he allegedly tried to push her off a cliff while they were hiking in Oahu. Quote, "When I got close to Gerhard grabbed me by my upper arms and started pushing me back towards the cliff's edge," she wrote. "He was yelling something to the effect of, 'Get back over there, I'm so effing sick of you,' and continued to push me. If I had fallen off the cliff, I would have likely died. Court documents described how Koenig then grabbed his bag and attempted to inject his wife with a syringe. As she fought back, she managed to throw it out of his reach, but he had a second vial in his hand and was searching for another syringe. The couple who lived in Maui were in Oahu celebrating her birthday at the time of the alleged attack. A judge granted a temporary restraining order on Friday, extending protection to her, their 2 young children, and other family members. Koenig remains held without bail at the Oahu Community Correctional Center. He was indicted by a grand jury last Friday, 1 day after his initial court appearance. Prosecutors played a clip from the 1993 blockbuster Jurassic Park on Wednesday during a hearing in the Gilgo Beach serial killer case, in what many saw as an unusual move to defend their use of DNA evidence. The scene from the film was used to support the legitimacy of the nuclear DNA testing that linked alleged killer Rex Heuermann to 6 of the 7 slain sex workers. His attorneys have argued that the evidence should be thrown out as unreliable. Nicole Navrosky, a prosecution expert witness and associate director at the Center for Human Identification at the University of North Texas, testified that the DNA analysis used in the case is not new and has been trusted for decades. To illustrate this, prosecutors played a clip from the 1993 film showing how scientists extracted dinosaur DNA from a mosquito trapped in amber and used it to clone animals extinct for millions of years. Navrosky said the DNA science referenced in Jurassic Park existed long before the 1993 movie and has been verified thousands of times in the scientific community, concluding that it is accurate and reliable for forensic use. Defense attorney Michael Brown dismissed the comparison, comparing the science to magic and arguing that Jurassic Park characters also thought they had good science before the dinosaurs ended up eating everyone. Investigators used this particular type of nuclear DNA testing because the hair samples from the victims' remains were severely degraded, in part because of the long gap between their deaths and their discovery in 2010 and 2011. Heuermann is accused of killing the women starting in 1993 and disposing of their bodies along Ocean Parkway in Long Island. Officials announced last month that their investigation had concluded and no further charges were expected. Wednesday marked the second day of hearings on DNA evidence, which began last Friday. No trial date has yet been set. Emotions ran high in a Florida courtroom this week when a grandmother was sentenced to prison for leaving her infant granddaughter to die in a hot car. On November 1st of 2022, Tracey Nix left 7-month-old Uriel Shock in her car after returning home from lunch with friends. Temperatures climbed into the 90s before the baby was found. Nix was convicted in January of leaving a child unattended in a vehicle causing great bodily harm, but was acquitted of aggravated manslaughter. Uriel was the second grandchild to die under Nix's care. In December of 2021, 16-month-old Ezra drowned after wandering into a pond outside her Wauchula home. Charges were dropped in that case, and the judge barred it from being mentioned at trial. During an emotional statement in court on Thursday, Kyla Nix Shock turned directly to her mother while talking about the trauma she continued to endure after the deaths of 2 of her children. "I still love you. I hate this," Nix said through tears. "I hate that I have to choose, but you know I had to. But it doesn't change my heart." Tracey Nix testified in her own defense during the sentencing hearing and for the first time spoke at length about the day Uriel was found left in the car. "I didn't realize that Uriel was in the car," Nix said. "I literally forgot for a long period of time. I'm broken about what happened," she continued. "I don't want to leave anyone with the thought that I'm making excuses because I'm not." Prosecutors sought the maximum 5-year sentence, with the judge citing Nix's lack of remorse imposing the full term. Before we get to what's on the docket for next week, I wanted to take a moment to thank you all for being a part of our growing community. But I wanted to give a very special shout out to Horse Girl G for their fantastic review on Apple Podcasts, as well as to our CC crew members, Lauren 2685 and Best NB1 for their support on YouTube. Keep them coming. We absolutely love hearing from you, and please tell us where you're from. We are thrilled by the growth of our international Courtroom Confidential community. On the docket for next week, Brian Walsh, the man accused of killing his wife Anna and dismembering her still undiscovered body in 2023, will return to a Massachusetts court for an evidentiary hearing on Monday, April 7th. Jeffrey Ferguson, an Orange County judge, is set to be retried on Monday, April 7th after his first trial for the shooting death of his wife Cheryl ended in a mistrial last month. The jury was deadlocked at 11-1 in favor of guilt on second-degree murder. 6 of the 7 suspects charged in the 2023 fatal beating of Arizona teenager Preston Lord are scheduled for a status hearing on Monday, April 7th. The 7th suspect pled guilty to manslaughter last month. Shanna Gardner, the Florida woman accused of plotting to have her ex-husband Jared Bredigan killed in 2022, will be back in court on Tuesday, April 8th for a case management hearing. Idaho College murder suspect Brian Koberger has 2 motion hearings scheduled for Wednesday, April 9th and Thursday, April 10th. Eric and Lyle Menendez will be back in court on Friday, April 11th for a hearing on LA County District Attorney Nathan Hockman's motion to withdraw the resentencing request filed by former DA George Gascon. The brothers have spent more than 3 decades in prison for the 1989 murders of their parents in their Beverly Hills home. And finally, please join us on YouTube this Sunday for our special question and answer series, Sunday Fun Day. All are invited to leave us a voice message at thecourtroomconfidential.com, which we will answer during a live stream at 9 a.m. Pacific, noon Eastern. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.